I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Lucia versus SEC, or Securities and Exchange Commission, a 2018 decision from the United States Supreme Court. This case is about presidential appointment powers and inferior officers versus agency staff, and where we draw the line really between inferior officers and kind of the lower level regular civil service employees of the federal government. So this isn't about principal officers versus inferior officers. It's about inferior officers versus agency staff. Our main takeaway in this case is the administrative law judges in the SEC are inferior officers, according to the Supreme Court, for purposes of the Appointments Clause in the Constitution. And that means that they're not just regular employees, and that in turn means that they must be properly appointed, not just hired like other agency staff. Now, I pulled this chart out of the casebook that I used for my course, and this is sort of a generic diagram or org chart of a federal administrative agency. And as you can see, there's a couple of tiers at the top, an administrator and then an assistant or deputy administrator, and those people are usually appointed by the president and have to go through Senate confirmation. And then we have some tiers, kind of the next two tiers here on the org chart. And if you look at the far right on my diagram, you'll see the Office of Hearings and Appeals and the Administrative Law Judges or Appeals Board. And most federal agencies have some sort of adjudicators who hold administrative hearings for that federal agency. And the question is, what do they count as? They don't have to be appointed directly by the president. The question is, can they be, and they be subject to removal? There's no question if you go to the bottom tier of this agency that you have people who are clerical staff and analysts and sort of the rank and file civil service employees that make up a lot of the federal bureaucracy, and they can just be hired by human resources. Or here's a little diagram I made. In a typical agency, you have the tier that are the principal officers at the top, and then sort of this middle tier of inferior officers. It doesn't mean that they're inferior, like less worthy or something. It just means that they are a step below the top in the chain of command. And then in the bottom tier, there's this kind of large group of agency staff who are just regular civil service employees. So why does this matter? Well, it can have there's some legal implications, both in terms of how they can get their job and then how they can be removed from their job. And so the top officials in agencies have to be appointed by the president. They have to go through Senate confirmation and normally are subject to direct removal by the president. Now, in a few cases with agencies like boards and commissions, the president may have to show some sort of good cause for that removal, but basically the way these people get removed from their position is typically either by impeachment or by the president firing them. And then you have this sort of middle tier of inferior officers, and these are mid-level officials in the government. They still have some authority, right? They have a lot of subordinates in the agency or exercise a lot of discretion, and they can be appointed and removed by the president or by others, maybe other presidential on the level of like the top principal officers who the president appoints. And then you have a lot more people in the bottom category of regular agency employees. So these are lower level employees who are basically hired and fired, usually by human resources under the Civil Service Act. And currently, the way the law stands now, the president actually can't fire these people, let's say, over political differences. They have their promotions and hiring and firings depend on merit, on how they're doing their job. Okay, so let's talk about the parties in this case. We have Ray Lucia, and he has an investment company and also has a popular book and radio show and would go around the country doing investment seminars. It was kind of a big deal. And the SEC Securities and Exchange Commission began an administrative enforcement proceeding against Ray Lucia and his company. He was marketing a retirement savings strategy called buckets of money. And the SEC claimed that he was using misleading slideshow presentations, basically to deceive prospective clients. And they charged him under something called the Investment Advisors Act. You don't need to know much about that to understand this case. Just understand that there is a federal law that regulates investment advisors and who's allowed to give investment advice and what they're allowed to claim and what happens to them if they make false or misleading claims and so forth. And the claim was that he was violating that act. And so the SEC assigned the case to one of its 5 administrative law judges named Cameron Elliott, pictured here. And he held a hearing and as the ALJ, and he issued an initial decision concluding that Ray Lucia had indeed violated this federal law and imposed sanctions on him, civil penalties of $300,000 and a lifetime bar from the investment industry. Well, that's a lot of money, and this is Ray Lucia's sort of livelihood and or career is in the investment industry. So for him personally, this is a big deal. So Ray Lucia appealed this to the SEC, and then from when he didn't get the SEC to change its mind or reverse the ALJ, he proceeded into federal district court. And instead of attacking the merits of the case and saying he didn't do anything wrong, his primary challenge is under the Appointments Clause of the Constitution, which says that only the president or courts or heads of departments can appoint inferior officers. So he's not claiming that the ALJ is a principal officer. He's claiming that it's an inferior officer. But in the SEC, that's not what had been happening. It's some of its lower level staff, basically human resources directors, had hired these administrative law judges for the SEC. So what Lucia argued here legally, and this is important to understand in administrative law, is that he's challenging the decision based on the kind of legal position of the person in the agency. So he argued that the ALJ proceeding was invalid because the ALJ himself, Cameron Elliott, had not been constitutionally appointed either by the president or the head commissioner of the SEC. And so according to Lucia, the ALJ therefore lacked constitutional or legal authority to do his job, which made his decision in Lucia's case legally void. Now, this goes to the U.S. Supreme Court, and the sole question before the Supreme Court was not the merits of the case or the validity of this statute that Lucia is charged with violating, but whether the ALJs are inferior officers or simply federal agency employees. And I want to make sure that my students understand something here. In administrative law, we study a number of cases about appointment powers, and some of them are about the difference between principal officers and inferior officers, and others are about the difference between inferior officers and regular agency employees. And this is the second type of case. So don't mix it up. Even though it's still about appointment and removal powers, don't mix it up with the cases that are distinguishing inferior officers from principal officers. Everybody knew going into this case that the ALJs are not principal officers. The question is, are they inferior officers or regular employees? So let's go back to my slides here. So to qualify as an officer rather than an employee, the individual has to occupy a continuing position established by law and must exercise significant authority under federal laws. And this is where, if you read this case, in the casebook I use in the current edition, this is a kind of a lengthy note case. It's starting to show up as a lead case in a lot of administrative law casebooks. And if you read the case, the court relies a lot on another case from a few years before called Freytag versus Commissioner, which in some ways is it's an easy connection to make. It's very analogous because it had addressed special trial judges or STJs of the United States Tax Court. The difference is even though the special trial judges in Freytag were holding administrative hearings, just like ALJs and other agencies, everything with the tax court is a little different than some of the independent agencies like commissions and boards. Now, in Freytag, the STJS could issue final decisions of the tax court in a few comparatively narrow and minor matters. And the court had held that the STJs were inferior officers, not just employees, applying another case that you probably talked about in administrative law, Buckley v. Vallejo. And they did this in Freytag based on the authority that these special tax judges wield. So the government in that case, in Freytag, had argued that they were employees in all cases in which they could not enter a final decision, because what's typical for both ALJ, administrative law judges, and these special tax judges were that they would issue a recommended decision that would typically be rubber stamped by the agency, but it wasn't final in and of itself. In other words, you had to kind of wait for the agency to adopt the recommended decision as its own before you could seek judicial review. Now, let's go back to Lucia, the case we're talking about here. The court here held that the Securities and Exchange Commission's ALJs are inferior officers under the Appointments Clause, just like in Freytag. This shouldn't come as a huge surprise. And the ALJs here are exercising significant discretion and authority. They conduct adversarial hearings. So you have lawyers from the S.Ct come in and explain why in the hearing are there explaining why they think Lucia violated this federal law, and Lucia and his lawyer is there saying why he didn't, maybe. And so in that sense, they function a lot like federal trial judges. Except there's no juries, and there's a few other differences. And the ALJs take testimony, they conduct these trial-like hearings, they make rulings on evidence and how much weight to give evidence and whether to accept it into the record, and they can enforce discovery orders like subpoenas. But here's the catch. The SEC ALJs would issue initial decisions that contain factual findings, legal conclusions, and appropriate remedies. And it wasn't automatically a final decision like that immediately. Instead, there was kind of a waiting period to give the SEC a chance to reverse the ALJ if the commissioners wanted, if they disagreed with the opinion. But if they didn't review it and reverse the ALJ's decision, after some time, the ALJ's decision would just automatically become final and be deemed the action of the commission. So I hope you can see that this was the sort of wrinkle or the ambiguity in the case going into the Supreme Court was, are these final decisions by the ALJ or not? Because when the ALJ first records it or issues the decision, it's not final. The SEC could still reverse it. But at some point, if the SEC doesn't do anything, it just sort of automatically becomes deemed to be the action of the commission. Now, I want to point out a couple other highlights from this decision. And this is sort of important for how Lucia affected sort of the next step in developing this body of doctrinal law about inferior officers and how we draw the line, what counts as an inferior officer. The court here focused really on how much discretion the administrative law judges have and the types of things they do with holding hearings and making evidentiary rulings and so forth, and not whether they have the final word on decisions. So that point I made on the last slide about how technically the SEC could still reverse the ALJ, the Supreme Court decided that they were just going to sidestep that and focus on the amount of discretion or authority that ALJs really have in practice and what they're doing at their job. The other reason this case matters right, this case is really just Ray Lucia wanting to attack the legal validity of his adverse decision from the SEC. And maybe this applies to the other ALJs in the SEC, but remember, there's only 5 administrative law judges in the entire SEC. They don't do a lot of adjudications compared to some agencies like the Social Security Administration. But there were a lot of other federal agencies who's had been doing the same thing with having human resources hire their ALJs instead of appointing them. So a funny thing happened while this case was pending. The SEC decided to kind of hedge their bets, regardless, whichever way the case was going to come out. And so when they realized that the way they had been hiring ALJs left them vulnerable to attack, they just had the SEC chair sort of reappoint the existing ALJs, the 5 ALJs there now can keep adjudicating their cases, except now they have been appointed, hired not only by HR, but have an official appointment by the chair of the Securities and Exchange Commission. And they did this just to be on the safe side, which solved the problem for all cases going forward. So for future SEC cases, this doesn't make any difference. The SEC just immediately had the chair reappoint their 5 ALJs. And the court here in Lucia's case ordered a new hearing before one of these duly appointed ALJs. So Ray Lucia gets a second time around, or second bite at the apple with this. And the court did specify not the same one. So it's not going to go, his case wasn't going to get reassigned to the same administrative law judge, ALJ Elliott, but to one of the other 4 who worked for the SEC. Okay, so that concludes our lecture about Lucia versus the Securities and Exchange Commission, about presidential appointment powers and how we define inferior officers.